Hi everyone, this is Steve Broach. I'm a barrister who specialises in the law affecting disabled children and young people and those with special educational needs. And I'm making this video for Special Needs Jungle to look at the implications of the new coronavirus bill that's been published today to deal with the current public health emergency and what it means for disabled children and young people, those with special educational needs and those around them. Now, the first thing I should do is give a health warning because the bill is brand new. I've only just been able to finish looking at the bill and its explanatory notes, and so I cannot guarantee that everything I'm saying now is going to be complete and accurate, but it's an immediate reaction to what seems to me to be the key issues in the bill. And secondly, just to stress, it is only a bill at the moment. It's not yet law. There is an opportunity for it to be amended as it goes through Parliament, albeit that, of course, it will go through very quickly and the government has a very significant majority, so we can expect at least most of what's in it to remain. There are three key areas that I want to look at for the video this evening. First of all, what the bill says about adult care and support. Secondly, what it says about the scheme in relation to special educational needs itself. And thirdly, briefly look at what the implications of the bill are for the Mental Health Act. So in terms of adult care and support, this is definitely the area that I found the most striking and in many ways the most shocking looking at the bill, because in essence what it does is suspend or disapply almost all of the key provisions of the Care Act 2014, and in particular the duty to meet eligible needs for disabled people in Section 18 and their carers in Section 20. It also disapplies most of the transition provisions for young people moving in to adult social care. And instead of having these duties, the local authorities will have a power to do all these things and a duty to provide services where it's necessary to avoid a breach of a person's convention rights, so their rights under the European Convention on Human Rights. And the difficulty with that is that the cases so far show that the threshold for where there's going to be a breach of someone's human rights in not providing them with care and support is pretty high. And so we may find that disabled people are being left without care and support in a situation which has a significant impact on their well-being, but where there is not a breach of their human rights and so no requirement to provide them with care and support when the bill goes through. So that's the first major area of concern. The second area of concern is what the bill says about the special educational needs scheme. Now, there's in Schedule 16 to the bill, there's some powers for the Secretary of State to vary or disapply or modify some of the statutory provisions. So, for example, in terms of disapplying, the Secretary of State will have the power to disapply Section 43 of the Children and Families Act, which is the duty on schools and other institutions to admit a child where they are named in the child's EHC plan or a college for a young person. So that could go if the Secretary of State makes the relevant order. Equally, the Secretary of State can also vary various provisions of the Act. So if we think about some of the key provisions the Secretary of State might be able to vary, Section 42, which is the core duty to secure special educational provision and healthcare provision in accordance with an EHC plan, the Secretary of State can change that duty so that instead of being an absolute duty, it becomes a reasonable endeavours duty. So the Secretary of State will merely have to, the local authority or the clinical commissioning group will merely have to show they've used reasonable endeavours to discharge the duty, which clearly creates a much lesser entitlement for the period of time that this legislation remains in force, which appears to be up to 2 years. So then the third area of concern is what the bill says about the Mental Health Act, and there are various changes to streamline the operation of the Act, in particular allowing people to be detained on the authority of only one doctor rather than two. And so in essence that will make it easier for people to be detained under the Mental Health Act. And I suppose my big question in relation to all of these proposed changes is, are they strictly necessary? Are they a proportionate response to the challenges that are created by coronavirus and by the current public health emergency? It's not immediately obvious to me, for example, that in order to respond effectively to the outbreak of coronavirus, we need to remove disabled people's entitlement to adult social care. It's not immediately obvious to me that we need to turn an absolute duty to meet disabled children and young people's educational and health needs into a reasonable endeavours duty, which is a far lower form of duty. And so I do hope that MPs and peers who are scrutinising the bill, while of course they'll recognise the need to support the government to respond effectively to the current situation, do ask these questions and do ensure that any of these powers that are given to the Secretary of State or any disapplication of the current law, it is strictly necessary, because what we're talking about here is eroding the hard fought for rights of disabled children and young people with special educational needs and their families, and that's not something we should do lightly. I hope this has been a helpful summary of some of the key issues coming out of the bill. I will be tweeting, as usual, about these issues as often as I can. And most of all, I hope that you and your families are able to stay safe at this very difficult time.